We are here in the matter of Dennis Bell versus Jesus Miranda, case number 25-02867-CH. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter is before the court just simply for a status check-in on whether or not the terms that I stated in my last order have been accomplished. So I guess I will go first to Mr. Bell. Mr. Bell, are we in a good spot today?
Your Honor, I'll tell you what's going on. He moved part of the fence, and then he says he doesn't have to move the other part because he said, hey, he didn't care what the court says. He's only going to move part of it. And I told him, I said, do you understand what you're saying? I said, Judge Rossi's, order is gospel. I said, you have to move the whole fence because you got to move the whole fence to have clear passage. So he just moved part of it. When he said he wasn't going to do it, no matter what the court said, I had to leave it alone, Your Honor.
Okay. And when you say there's not clear passage, do you mean that if someone's driving that big vehicle we talked about last time, that now there is what I'm going to call a jog in the driveway that they have to navigate?
You got it, Your Honor. When you gave the order, it was spot on, right? The gas meter over to the fence. When he did the first part, it was spot on, and I commend you on that. That was the right thing to do. We opened up the passenger door as you recommended, and it was clear.
Cool.
Then, as we proceeded past the house, right? As you proceeded past the house, now when you go past the house, you can't. It's like you just said, it's jogged. So therefore, that's an accident waiting to happen. A person's going to come out of there, either going to hit his fence or it's going to hit the house, right? So, and I said, listen, we don't have a say on this. Judge Rossi made the order. We just got to follow it. He said he didn't care what the court said. He's going to do what he wanted to do. And you can see the arrogance of what he has just done. He didn't follow your order. He stood me up on the first appointment, and I was over there waiting. He didn't show up. So, Your Honor, I don't know. I'm throwing my hands up on it. I don't know what to do. I mean, if he disrespects the court and disrespects you, then I don't stand a chance. So, you know what I'm saying? And
I hear you, Mr.
Yeah,
Bell. Let me hear from Mr.
I'm
Miranda
done. You know
and
what
see
I'm saying?
what his argument is here. Yeah, I
Yeah.
hear the frustration and I understand
Oh,
where it's coming
goodness.
from. And part of it may be due to, me being very clear about, hey, you got to clear this gas meter, but not necessarily as clear about what we got to do with the rest of that, fence. Let me hear from Mr. Miranda.
Good morning, Judge. I did move the fence as it was written on the order on the nearest place from the house.
Yep.
The one part that Mr. Belt is talking about, you can actually see it on my screen. There's a pickup truck parked in there with the two, with all the four doors open. That's the spot that he's talking about.
Yeah, so a person now they come up that driveway, they can clear the meter because you moved the fence, and then
Correct.
behind you in the corner of the screen, I'm seeing what I'm going to call that jog that looks like it's about 6 fence panels. And the person then has to either, like you got a car parked there, and it looks like that person, you're saying, well, Judge, they can park, they can open the doors,
Correct.
they can access that.
Correct.
It- you know, uh, it, and what's beyond that, Mr. When a person drives past there, do they go into like a parking space, or what's beyond that?
Correct. Correct. There's a parking space. If I move my fence according to how Mr. Bell wants me to move the fence, then the whole property becomes a shared driveway and he won't be able to park any cars, period.
And why do you say that?
Because then it'll become a chair park, then it'll become a chair driveway throughout the whole property, and then he has no private property to park any vehicles.
You're
There's not
thinking
gonna
if you move the fence, because then in your view you're giving up more of your property
correct.
to this easement, and and then, or, or whatever we're going to call the, the driveway, that then you've got a right to use it too, and you're going to be contending with your vehicles going in and out. Now, it doesn't really make much sense. You don't have any reason to park and utilize the house, right?
Correct.
Okay. Yeah. Well, here's going to be
Yeah,
my,
there's. I'm sorry.
yeah. Go. Do you have something more to say, Mr. Renner?
No, no, no. I was just gonna say that there is enough. Uh, there's enough way to go all the way to the house, as you can see on the picture where I'm talking.
Yep. Let me go back to Mr. Bell. Mr. Bell, now I'm looking at that picture. It looks like, though I get it, there is a jog in the driveway. It's less than perfect, probably, as far as driving conditions. It certainly wouldn't meet the Michigan County Road Commission manual for roads, but as driveways go, it doesn't look like it's impossible to navigate. Am I seeing something wrong?
Well, Your Honor, first of all, we do not want this to be an obstacle course, right?
Right.
You know what I'm saying? We
Right.
want to be able to, these tenants, and if I sell the property, they want to come in, park their car, and go about their business. And he thinks that this driveway is his. That's the problem. He doesn't understand what an easement is. It's obviously he doesn't, right? And this easement has been in place for 40 years before he bought it, before I was over there. So now all of a sudden now he wants to come in and take part of that easement away. I
Was there
understand.
always a fence there?
Never
Uh,
was a fence.
there always was sometime.
No, it never,
No, it's
no.
just open land before.
Yes,
Yeah,
yes.
I
Yeah,
see.
it's been there forever. And
Yeah,
yeah, and now all of a sudden you come in and you know what a prescriptive easement is. If been over there 15 years unabated, it becomes permanent because that's the way these people were using to get to the backyard. And now, no matter what he says or what I say, you can't overstep the boundaries of what the definition of it is. So,
yeah.
for some reason in his mind, he thinks that property is his. Now, Your Honor, I got to say this. I don't care what happens after that. He can gain property. You know what I'm saying? He can have whatever's over outside that driveway, and he can have whatever property for whatever his lot is. But we definitely can't have it as a hindrance to the tenants, is what I'm saying. Now look at that. That looks terrible. You come in there, you're going to hit that fence, Your Honor. I promise you. You're going to eventually, somebody's going to hit that fence, or they're going to hit the house. There is no question about it.
Well, and of course, if they hit the fence, because Mr. Miranda's fence, then he's got to, that of course, then the person has to deal with their car damage. But
Yes.
that he's got to figure out. I mean, to some degree, he's taking the risk. You're right, because I would agree that corner does present.
Awesome.
At least, I could drive my little Chevy Volt through there 100 times. You ought to see how tight it is to get into the courthouse because we got a it was built right after that Oklahoma City bombing, and they made a real tight turn to go in to make sure we're safe with the
Yes.
bike. But I'll tell you, you don't want to be driving a full-size pickup into our
No.
courthouse park, and it's tight as
No.
can be. So, well, here's, and I again appreciate, both parties have come in here, and you're following the law and doing this thing the right way. You're not resorting to self-help, which I appreciate. However, my order at this time is, another nature of easements in general is there is a rule that goes along with them that say they should be enforced by the law in a way that's least burdensome to the person losing property, who in this case is, it's not a person, as you point out, Mr. Bell, losing property. Really, this is an easement that's existed for a long time.
Right.
It's been, arguably in place long enough to be a prescriptive easement. But an easement nonetheless is a permission to utilize what they call the burdened property, which is Mr. Miranda's property. There's a second principle that goes along with them that says, well, when you grant an easement, that it should be in the way least burdensome to the property that's burdened, because after all, we're saying here that the easement works a taking of what would be the surveyed property line and allows, in your case, access to a rental property. However, and you identified last time the fact that, hey, there's a choke point there by that gas meter that just simply isn't wide enough to allow passage of even a wide car, and thus, that's never going to be rentable. And I ruled in your favor there. This time I'm going to go the opposite and say, though, that this isn't ideal. It does allow access. Mr. Miranda did put up a picture of a big truck there with its doors at least part the way open, even at the narrowest point of the driveway. So my ruling is that he's accomplished the purpose of that, easement that you're arguing for. And after all, another thing that happens here is when a fence goes up, for example, that serves as sort of, an acknowledgement to the whole world that, hey, now this easement is here. It's acknowledged by both parties, and this is going to be the line of it. I understand Mr. Miranda is wanting to protect as much of his property, even though I understand the argument there is, well, he doesn't really utilize the other end of the property. There's not that much burden on him if the fence is, 3 feet farther or 3 feet not. Nonetheless, he is giving a portion of property through that law of prescriptive easement so that you can and your tenants can have access and your business can be conducted. But I'm not going to modify the order again. He has, in the very basis sense, complied with the order because I said it's 12.6 from the meter. I didn't say about the rest of the driveway. It does appear to be passable, which is the overall intent of the order. So at this time, I'm going to decree that the order's been complied with and close the case. I know that's not exactly what you would like, Mr. Bell, and if you wish to approach me to reconsider it, or you think there's more relief to be obtained here, like I explained before, the trouble with that is, it's all a matter of weighing and balancing cases. I have had cases involving easement and lake access and stuff like that they drag on for years and they cost tens of thousands of dollars. And and I always ask the participants, well, you got to say, here's the value I'm getting out of this. Is it equal to the cost of enforcing what I believe are my rights? And I believe the base right here, which is passage, safe passage, onto the rental property for parking, loading, unloading, etc., is protected. So I'm going to rule that it's been complied with and close the case. And again, gentlemen, thanks for bringing this before the court as opposed to going out and taking matters into your own hands. Go ahead.
Well, there's several cases now, Plymouth Canton versus Cryer versus Prost in 2000, that said that if someone uses a neighbor's land openly without permission and continuously for 15 years, they earn the legal right to keep using it. Also, too, it goes on.
No, I enforce that against the church up in Northwest Grand Rapids. I believe in easements, even at the detriment of probably a whole congregation now that is going to vote against me in the next election. So
no, they probably won't, But also, too, it goes on to say, Your Honor, Matthews versus the Department of Natural Resources in 2010 said a prescriptive easement becomes permanent after 15 years of use and passes to future owners. Also, too, Your Honor, in 1997, Sherwood versus Burrow said you don't need to be the only user, just open adverse continuous use for 15 years, that becomes permanent. So anybody who comes in and puts a fence down the middle of that driveway is really going against the Michigan state statute.
Yeah, they're the ones that are doing the taking. Well, here's the issue with easements and my the way, because I've and another thing I got to say here is I never practiced real estate or property law. As a private lawyer, I only touched on it in a few cases, and I did take it in law school because it was required. And since I got this job, I get a lot of real estate cases. I wish I'd listened better to my professors 30 years ago. But the fundamental issue I experience with easements is, of course, first of all, you got to define, what's the easement there for. And in your case, it's pretty clear. It's a driveway. It's not a road. It's not a two-way traffic or anything like that. It's a driveway that'll allow access to your property. And then what is, and obviously, I had a case involving some lakefront property where a guy puts a plate structure right across the other guy's easement, so he couldn't drive a vehicle down it anymore. Well, that obviously then you make the easement unusable. Well, that the other corollary of that law, like I said, when you're defining the scope of the easement, that is how wide that access road is. Because, usually when people are utilizing it in that open and notorious way, they're not putting down curbs and lines or anything like that to define the width of the easement. Then the court has to define it as a reasonable width. I'm saying the reasonable width here is to allow access. It's not, in quotations, perfect access, but I also live in East Grand Rapids. I think I've had to make tighter turns than that to get into my own garage a few occasions. It's not unknown that you have a curve or a jog in an access driveway or road. So I'm going to stick with that. I understand where you're coming from, Mr. Bell, and frustrations with it. Just know that I share those frustrations. There are about a million cases
Yeah,
out there on easement and
we
property
respect that.
laws.
No, we respect you. But also
I
too,
wish it was more crystal clear.
yeah. Also too, Your Honor, we never did address the damages. Do you want Can I take that up in small claims, or do you want to address it,
Well,
or
I thought
because
that I said right that because Mr. Miranda did move this, and there was some argument, but the original mediator's order didn't contemplate an award of any money to either side, that I was going to stick, because at the end of the day, I'm trying to enforce that and clarify the original
true?
mediator's
I
order.
understand that. I do. I understand. I respect that, but we never did address that. So what I'm saying is, I should have the right to address that. I don't know under you or in small claims. I still, because we did suffer, Your Honor. We
Yeah,
really did.
well,
I mean,
and
we did.
yeah, I guess the answer is, if you think that it wasn't adequately addressed or unaddressed
It
by
wasn't.
my order enforcing the mediators, and I don't have the mediators, I just have my order in
Okay.
front of me now, that you can bring it back. I don't think it's a perfect claim. I think it, may get attacked on the fact that, hey, we worked this all out before, because usually when you get an order in a mediated case, the goal is to resolve all of the issues
Yeah.
arising out of that. However, I don't want to opine on the breadth of that opinion right now. I don't have it in front of me. So,
Okay. So
but
we can bring that later, you said? Because we
well,
definitely suffered,
I'll
Your Honor.
leave that to you and your attorneys to do an analysis and see if there
Okay.
is anything worthwhile
He
to
did
do.
say we had a case, Your Honor. He really did, because whenever you start losing money because a person puts in a spite fence, and we really do believe it was a spite fence without any doubt. I mean, and spite fences do get awarded damages when that is happening. And this was a spite fence. Even the city of Grand Rapids talked to him about putting the fence down the middle of a shared driveway, which caused my tenants damage, caused me financial damage.
Yeah, I
So,
remember you said,
yeah,
right, it
no, we
came
have a
during
case.
a tough
Yes, we
time
do.
because you didn't feel like you could raise the rent when they're
Good,
struggling to access the house,
right?
and I get that, and there is economic reality. And
Absolutely.
the only thing I can warn you about, Mr. Bell, is sometimes enforcing, especially in a court of law, gets more burdensome and expensive than the money you get out of it. So,
Uh,
but I'll leave that to you to do that calculus. You seem like a person who's more than capable of putting
yes,
a
we
couple of
are.
facts together in your head. So.
We can put that. Hey, you are. And here's what I need to ask you. Can we bring that in small, or do we have to come back to you?
No, it would be a separate case because I'm going to close this one today.
Okay, yeah. So therefore, we can bring that. We don't have to come back to you. We can go to small, right?
You do, but you're still going to have to contend with any, arguments that it's already worked out in this case. So, yes, but you could bring it into small claims court, and
Okay.
And I
Because you're gonna close the fence portion out, and that's the only thing that we're gonna address today. Is that correct?
Yeah,
Okay.
I'm closing out with my, I'm going to say my order's been completed and close my case, and therefore, and then that, what we do in every legal case is it creates a record. There's a paper
Yes.
record that includes that mediator's order, my order enforcing it, and then my closure. And then, from a legal standpoint, that gives you whatever rights or rights that weren't addressed in the case.
There you
Uh,
go.
could still
Okay,
be
yeah,
open. So
'cause, yeah,
that's where we stand at the end of
Okay.
today, and I'll let you and your lawyers analyze the next step.
okay,
Can I-
thank you, Your Honor.
Can I
Appreciate
say
it.
Yeah,
a quick word?
yeah, go ahead, Mr. Miranda.
Uh, I just want to say that he tried suing me through small claims once before, and the judge dismissed it.
Well, and that could happen again because, as I said, one thing that we do pretty well in the courts is we give effect to other courts' orders, and at every level, but especially at the small claims and district court
Right.
level, every judge is swamped with more cases than they can deal with. So if it looks like another judge has issued an order that encompasses what's being argued about, usually that other court will enforce the order, but that is very dependent on the language of the order, and I've already
absolutely right.
issued
You're right, Your
my
Honor.
order here. So
This was about the case that was dismissed as the one you're handling, because you're right, we had to come to circuit court. That was the issue. You're right.
right.
You're right. It was
So
circuit
yeah,
court.
nope, and I don't want
Yeah.
to, I don't want to get out of my lane here and
No,
talk
you're
about
smart.
what
You're a
might
smart
happen in
man.
another
You,
court. So,
you're a smart man. You know what you're doing.
yeah, that's one thing I have learned. So, all righty, gents. Well, I wish
Thank
you
you.
both luck, and as I say, I really appreciate you turning to the courts instead of a sledgehammer. That never works out well for anyone. So,
Thank you, Your Honor.
thank you.
All right.
Thank you so
Bye.
much.
Bye.